The Indiana Supreme Court just wrapped up a historic hearing on the law, the first abortion ban passed after Roe v. Wade was overturned last summer. Let's turn to News 8 government reporter Garrett Bergquist, who watched every minute of the legislative process and this morning's hearing in front of the state's highest court. Garrett.
Good morning. Those arguments just wrapped up within about the past hour. The court has to decide whether to leave in place a lower court's order to block the abortion ban until the court system gets a chance to take a closer look at it. This particular case turns on the opening words of the state constitution, namely language stating a right to life, liberty, and the pursuit of happiness, the same words in the Declaration of Independence. The ACLU argues that language effectively guarantees a right to privacy and personal autonomy. The state points out there are no specific liberties guaranteed in that part of the Constitution. That led to some intense questioning from the Supreme Court. Here's a little of that exchange.
We found some core issues in Indiana with regard to religious freedom and political speech. If there was ever going to be a right in Article in Section 1, and we look at the test you want, which is the same test as Glucksberg, SCOTUS, a woman has the right to make a decision with regard to saving her life.
I'm perfectly fine with that.
Okay.
Now, I think I guess I want to push back a little bit on the use of the precedents. I mean, I don't think that Schmidt was saying, well, Article in Section 1 is fair game, but it's just not about alcohol. It was saying, we don't know what principle the court was using in those cases. Later on, whenever the court used Article in Section 1, it was always paired with something else. The Leach case wasn't strictly about Section 1. It was about understanding the right.
Currently, they found a right to scalpers in
not
Article
on its own.
Section 1.
That was paired again with Article in Section 23. It was never on its own. It was never the only source of rights. It was asking the question. And the question it was asking, I just want to say in curtly, the question that was being asked goes back to what I suggested earlier, which is this a proper use of the police power?
The court will issue its ruling at a later time, and once again, the case involves the court order, but not the underlying privacy question. And there's also a separate case from Marion County that challenges the law under Indiana's Religious Freedom Restoration Act. That case is still working its way through the court system. Live at the State House, Garrett Bergquist, Wish TV, wishtv.com, and follow us on Facebook.